This video is going to focus on the appeal or review process done by the Independent Review Panel, also known as the IRP, after the governing body has made its decision. It will also provide more information about what to expect at an IRP hearing. Please see the previous video for more information on what a governing body decision means and factors that may affect your decision whether or not to appeal it. Where the governing body has upheld a decision to permanently exclude a pupil, the parents have the option to request a review of that decision. This review, also known as an appeal, is to the Independent Review Panel. This option is only available for permanent exclusions, so will not apply to any other kind of exclusion. So what does an IRP do? If a parent's request is received within the 15-day time limit, the local authority, or academy trust if the school is an academy, must arrange for an IRP hearing. The IRP's role is to look at the governing body's decision and decide if that decision was made in a way that was fair, reasonable and lawful. For more information on these concepts and whether an exclusion fulfills them, please see this video here. They will look at whether the governing body considered all the relevant legal tests, whether they followed the right procedural rules, and if they considered all the circumstances of the case. The Independent Review Panel does not usually reconsider the facts of the case, and it will not make a decision about whether something did or did not happen. For example, the pupil's behaviour which led to the exclusion. Rather, the review is about whether the governing body reached a conclusion about whether something happened, reasonably, lawfully and fairly. The Independent Review Panel's focus is on the governing body and not the behaviour of the pupil. Usually, the IRP make a decision based on the evidence that was available to the governing body at the time. In the rare case that there is new evidence available at the IRP review and the governing body would not have been able to consider this evidence at their own hearing, this evidence can still be presented at the review. However, the IRP cannot quash a decision or declare it flawed on the basis of this evidence. All they can do in this circumstance is recommend that the governing body reconsider their decision in light of this new evidence. For more information on the types of decisions that an Independent Review Panel can make, please see this video. So who will be at the hearing? The panel will be made up of 3 or 5 people and will include the following. The chair, also known as the head of the panel. They will be a layperson. This means that they will not have worked in a paid role in a school before. However, they are usually the chair of a governing body at a different school. Someone who is or has been a school governor for at least 1 year in the last 5 years. This person cannot have been a teacher or a head teacher. In the case of a 5-person panel, there will be 2 school governors. Someone who is or has been a head teacher in the last 5 years. In the case of a 5-person panel, there will be 2 head teachers. There are a number of people who cannot sit on the panel. Members or directors of the local authority, academy trust, or the excluding school's governing body. Someone who is or has been the head teacher of the excluding school in the last 5 years. An employee of the local authority, academy trust, or excluding school's governing body, unless they are employed as a head teacher in another school. Someone who has any connection with the school, governing body, local authority, academy trust, parents or pupil which could cause reasonable doubts as to their impartiality, and someone who has not received the required training within the last 2 years. The local authority or academy trust should take care to avoid bias or the appearance of bias. Prospective panel members should declare any potential conflict of interest as soon as possible. The panel members must have received training that includes certain topics such as the role and duties of the panel members themselves, head teacher, governing body, the chair and the clerk to the panel. There will usually be a clerk present at the IRP hearing. The clerk will often have knowledge of the law on school exclusions. This means that they can provide advice to the panel on whether or not the governing body or the head teacher acted lawfully when making their decisions about the exclusions. The clerk has a number of duties. These include communicating with all the parties, keeping parents informed of their rights, sending out all the details of the hearing, including copies of all the written evidence and details of everyone who will be attending, and taking minutes of the meeting. Some panels have both a clerk and a legal advisor. The clerk then takes care of all the administrative elements of organising and taking the minutes, whilst the legal advisor ensures that the panel members have understood all the legal implications of the school's actions. Parents have the right to request that there is a special educational needs expert present at the review hearing, regardless of whether or not the school believes the pupil to have special educational needs. This request should be included in the application for the independent review. The special educational needs expert cannot be appointed if they have ever had any connection to the local authority, academy trust, school, parents or pupil, or the incident leading to the exclusion which may raise doubts as to their impartiality. Being an employee is not enough to raise these doubts. However, they should not have had any previous involvement assessing or supporting the excluded pupil or their siblings. The special educational needs expert's role is to provide impartial advice on how special educational needs may be relevant to the exclusion. It does not include doing an assessment of the child's needs. If the school denies that the pupil has special educational needs, then the expert can advise the panel on whether or not the school took the right steps in making sure that they identified any special educational needs and how this may have affected the pupil's exclusion. The special educational needs expert will advise as to whether the school's policies relating to special educational needs and how they were applied to the pupil were legal, reasonable and procedurally fair. If the expert thinks that they were not, then they should set out how this may have affected the exclusion. For instance, it is not legal to exclude a pupil simply because they have special educational needs or a disability that the school feels it cannot meet. For more information on special educational needs or a disability, please see this video. Others who may be present at the review hearing: a local authority representative, a school and governing body representative. Both these representatives might provide their perspectives on the case. A parent's representative or a friend. Please see below for organisations which can provide representation and advice. The pupil. Excluded pupils are encouraged to attend and participate in hearings. They will be given the chance to express their views and their side of the story in person, in writing or through a representative who can speak for them, whichever is the most appropriate. Witnesses. Sometimes others will give their side of the story, and usually this will be through written statements. Occasionally they will attend the meeting and give their statements in person. So what to expect at the hearing? The panel will hear from all the people who were involved, and they will also consider all the written evidence available to them at the time. The independent review panel are not there to go over the whole facts of the case again, as I said earlier. Instead, they will be looking to see whether the governing body acted rightly in making their decision, so the focus will be on the way in which the governing body acted. In doing so, they will ask themselves a number of questions. Firstly, was the decision illegal? Did the head teacher or the governing body act in a way that they were not allowed to under the law? For instance, if the decision to exclude was because of reasons that were not related to the child's behaviour. Secondly, was the decision irrational? Did the governing body make a decision that wasn't sensible or logical? For instance, did they not consider all the relevant evidence, or did they make a decision that went against the evidence? And thirdly, was the decision procedurally improper? Did the governing body follow all the right procedures and do everything that they were supposed to do? If not, could this have had an impact on their decision? For instance, if they didn't give any or sufficient reasons for the decision that they made. Some hearings can take quite a while, even up to a whole day. It is important that the evidence that the IRP hears is always relevant and relating to the questions that the IRP must ask itself. If you would like to know more about the legal tests relating to exclusion generally, please see this video. The independent review panel will then make its decision. Please see this video to understand what these decisions mean and what happens after the IRP has made them. Thank you for watching this short video on school exclusions. The links for all the videos mentioned can be found in the description box below.
We hope that you've enjoyed the video and you found the information that you were looking for. If not, please visit our YouTube channel and watch our other videos for more information on school exclusions.
Bye!